projects to pay overtime did not apply to projects in Iran and Iraq. The court described the presumption as, quote, based on the assumption that Congress is primarily concerned with domestic conditions, and found nothing in the legislative history which would, quote, lead to the belief that Congress entertained any intention other than the normal one in this case. But the inconsistency in the application of the presumption continued. Over a strong dissent, the court declined to apply the presumption in Steele versus Bull of a Watch in 1952, where it held that the Lanham Act covered trademark infringement in Mexico. The court relied on a broad jurisdictional grant in the Lanham Act and the fact that the defendant's operations and their effects were not confined within the territorial limits of a foreign nation. And it distinguished American Banana on the grounds that there were no effects in the United States alleged there, but there were effects alleged here. The court also did not apply the presumption in a series of maritime cases, from Morrison to Benz to McCulloch. The presumption, however, came back with a vengeance in 1991 in the Aramco decision, which has already been mentioned, a decision holding that Title VII did not apply to discrimination by an American company against an American citizen in Saudi Arabia. There was, in fact, strong evidence that Congress had intended Title VII to apply extraterritorially in the form of a provision exempting the employment of aliens outside of any state, a provision that you would think unnecessary if the statute did not apply extraterritorially. But the court deemed that a clear statement that the statute applied extraterritorially was required and found it absent in Title VII. Congress, just parenthetically, quickly amended Title VII to apply extraterritorially. But once again, the court fell into inconsistency. It applied the presumption subsequently to the Patent Act, the Immigration and Nationality Act, and the Federal Tort Claims Act, but not famously to the Sherman Act in Hartford Fire Insurance versus California. So what does Morrison have to say about any of this? Finally, I get to Morrison. I think three things. First, Morrison tells us that the court will, quote, apply the presumption in all cases, preserving a stable background against which Congress can legislate with predictable effects. Now, given the inconsistent application of the presumption that I've just mentioned, this has to be taken as an aspirational statement rather than a statement of past history. But I want to suggest in a moment that Morrison's approach does hold the promise for bringing what might previously have been seen as exceptions to the presumption within Morrison's analytic framework. Still, I have to say, there's at least one category of statutes to which the presumption, I think, even under Morrison, clearly does not apply, and that is jurisdictional statutes. We know this because Morrison itself applied the presumption only to the substantive provision of the Securities Exchange Act, Section 10b. It did not apply it to Section 27 of the Exchange Act, which is the jurisdictional provision. In fact, in an often overlooked part of the Morrison opinion, the court went out of its way, Frank alluded to this morning, went out of its way to suggest that the district court had subject matter jurisdiction to decide the substantive question. Section 27 contains no clear statement that it applies to suits arising abroad. So clearly the presumption applies to substantive provisions, not to jurisdictional ones. And if you think for just a moment about that, that has to be true. U.S. courts decide cases every day that arise abroad under 28 U.S.C. 1331, the federal question statute under 1332, the diversity statute, criminal cases under 1832-31, which is the general subject matter jurisdiction provision for criminal cases. None of these contains a clear statement that it applies extraterritorially. We're going to find out, perhaps as early as Monday, what it thinks about 1350, which is the Alien Tort Statute and the presumption against extraterritoriality. But if the presumption did apply to jurisdictional statutes, then suits brought in federal court under substantive statutes that clearly do apply extraterritorially, like Title VII as amended in 1991, or like the Foreign Corrupt Practices Act, would have to be dismissed for lack of subject matter jurisdiction, because the subject matter jurisdiction provision wouldn't reach the case even though the substantive law does. That simply can't be the law. My second point, so the first point was presumption applies in all cases, except jurisdictional statutes. Second, and most significantly, Morrison makes clear that application of the presumption against extraterritoriality does not turn mechanically on where the conduct occurs. That was the traditional understanding of the presumption in American Banana. It's an understanding that has been repeated subsequently, even by Justice Thomas, joined by Justice Scalia in the Pasquantino case, for example. But it's an understanding that Morrison clearly repudiates. The plaintiffs in Morrison argued that the presumption didn't apply because the conduct at issue occurred in Florida. And Justice Scalia rejected that argument. Quoting Aramco, Justice Scalia emphasized the court must examine the focus of congressional concern. And he wrote, and this is the key sentence, for me this is the pivotal sentence in the entire opinion, applying the same mode of analysis here, we think that the focus of the Exchange Act is not on the place where the deception originated, but on purchases and sales of securities in the United States. Don't focus on where the fraud happened, focus on where the transaction occurred. That's what he says. Even if you think the court was wrong about the focus of the Exchange Act, and there I think reasonable minds can differ, I want to suggest that this is the right question to ask. And it's the right question to ask for at least three reasons. First, Morrison's focus of the statute approach acknowledges that the presumption is based on congressional intent. And this is a point the court has made time and time again. If it's meant to effectuate the intent of Congress, it makes sense to focus on what Congress focused on. I use the word focus too much. Second, Morrison's focus of the statute approach acknowledges that Congress's intent with respect to geographic scope may vary from statute to statute. And this point goes back at least to Bowen in 1922, where Chief Justice Taft wrote, "The necessary locus, when not specifically defined, depends on the purpose of Congress." And Bowen, remember, distinguished between different kinds of criminal statutes, ones involving the peace of the community, which were presumed territorial, and ones in which the government was defending itself against fraud, which were presumed to be universal. Third, Morrison's focus of the statute approach provides a way to explain what otherwise appears to be a very inconsistent series of cases. In some cases, the court has found that the focus of a statute is the place of the allegedly wrongful acts. This is generally true of the employment and labor statutes, which the court has generally found not to apply extraterritorially, in Aramco, in Foley Brothers, for example. Bowen states that in general criminal statutes, most criminal statutes apply territorially. And most recently, in the Pasquantino decision in 2005, the court held that application of the federal wire fraud statute to a scheme in the United States to defraud Canada of tax revenue was not extraterritorial because, quote, the offense was complete the moment the defendants executed the scheme inside the United States. The wire fraud statute punishes the scheme, not its success. So we know, for example, with that statute, the court has held the focus is on where the conduct occurs. But sometimes a statute focuses not on where the conduct occurs, but on the place of the effects. So Hartford Fire Insurance held that the Sherman Act applies extraterritorially to foreign conduct that produces substantial intended effects in the United States. Steele held that the Lanham Act applies to acts of trademark infringement in Mexico, noting that, quote, unlawful effects in this country are often decisive. Ford applied the National Prohibition Act, a statute we don't care about too much anymore, extraterritorially on the basis of effects. I have argued previously that focusing on the place of effects makes a lot of sense in most cases because that's what Congress is generally concerned about, preventing harmful effects. And if we think that one of the primary bases for the presumption is the idea that Congress is primarily concerned with domestic conditions usually means domestic effects. But it's certainly possible for a statute to have a different geographic focus. Morrison found that the focus of the Exchange Act is not on the place where the deception originated, but on purchases and sales of securities in the United States. That is to say, not on the place of the fraud, but on the place of the transaction. I've argued that Morrison can be understood as a kind of effects test or an application of the effects principle because the place of the transaction is where the effects of the fraud are felt, but it's obviously a narrower kind of effects test than the Second Circuit's effects test, which Morrison overturned. Other provisions of the Securities Exchange Act may have a different geographic focus. For example, I'm not a securities lawyer, just a disclaimer, but Section 17 of the Exchange Act, which only allows the U.S. government to bring claims, speaks not just about where the transaction occurred, but where the offer was made. An offer may be made somewhere different than where the transaction is ultimately consummated. So you may have to ask a different geographical question with respect to that provision. Now, admittedly, many of these past decisions did not understand themselves to be applying a presumption against extraterritoriality at all. Bowen said expressly the presumption should not be applied. Steele said it had been overcome by effects. Hartford just ignored it. But if the presumption is understood to turn not on the location of the act, but on the focus of the statute, which is sometimes conduct, sometimes effects, sometimes the place of the transaction, sometimes truly global, then one could say, as Morrison does, that the presumption applies in all cases without having to overrule the court's past decisions or find exceptions that fit them. The final aspect of Morrison that deserves attention is this discussion of what's necessary to overcome the presumption against extraterritoriality. Morrison states the requirement thus, quote, when a statute gives no clear indication of an extraterritorial application, it has none. Aramco, remember, had required a clear statement, but Morrison rejects that. It says, we do not say that the presumption against extraterritoriality is a clear statement rule, if by that is meant a requirement that a statute say this law applies abroad. Assuredly, context can be consulted as well. A very carefully crafted statement by Justice Scalia, who, as you all know, doesn't believe in legislative history, a statement that's broad enough for him to say, or ambiguous enough for him to say, I didn't mean legislative history, and for Justice Kennedy to say, I did mean legislative history. It is clear, however, from Morrison that boilerplate definitions of commerce are not sufficient. Here, Morrison follows Aramco, that a general reference to foreign commerce in the definition of interstate commerce does not defeat the presumption. I disagree with Professor Gewirtz here. I think that's right. The reason Congress puts these jurisdictional provisions in their statutes is to invoke their commerce power, not to say anything about the substantive reach of the statute. Reasonable minds can differ. It's still unsettled, I think, whether courts owe Chevron deference to agency interpretations of statutes that apply extraterritorially. Justice Scalia clearly thinks not. He said as much in a concurring opinion in Aramco. He quotes that opinion, that Aramco opinion, in his Morrison decision, but he specifically distinguished the Securities Exchange Commission interpretations on a different ground, on the ground that the Commission did not purport to be providing its own interpretation of the statute, but rather relied on the federal courts. I think it remains to be seen how the court would treat a truly reasoned agency interpretation that extraterritorial application was necessary in order to effectuate a statutory scheme. I think the court should defer to such an interpretation. That's a great note topic for anyone who's looking for a note topic. In conclusion, Morrison may or may not have been a positive contribution to securities law, but I think it is a positive contribution to the court's extraterritoriality jurisprudence more generally. It releases the presumption from the iron grip of lex locus delicti and allows courts to concentrate more sensibly on the probable focus of congressional concern in defining a statute's geographic scope. This may sometimes be the place of the act, but it could be the place of the effects, the place of the transaction, or every place where the conduct might occur, thus allowing us to harmonize the court's past decisions. Morrison also sensibly declines to make the presumption a clear statement rule. Whether lower courts will apply Morrison sensibly remains to be seen. Thank you.
Okay. Well, I'm sorry that all of the students are leaving because I wanted to say something. You really should read Professor Curran's brief in the Kiobel case. Because when she was talking here there were certain assumptions made about what the participants in this conference know about securities law, international law, that may have made a few sentences that she said go over your heads as students. But when she wrote the brief, she was writing for people who were not necessarily experts in the subject. And it's absolutely brilliant working to convince you that civil law and criminal law are the same. Not the same, I exaggerate here, but are very similar in certain ways in the two civil law and common law systems. So I would suggest that you do that. I want to say that I'm going to start by agreeing with the most important thing that Professor Dodge says, and then perhaps disagreeing on some of the details. And I think that the quote that he gave you from Morrison is really important. The idea of a stable background for Congress to legislate with predictable effects. We want to know what law it is that Congress has made and who it applies to. And now I'm going to say something which may sound crazy to some of you, but I assure you it's true. As you sit here today in the United States, you cannot technically know exactly what countries have the legal authority to control your conduct. And the reason that's true has to do with the misfit between the criminal law and international law. The idea is this. Generally, when you are arrested for a crime, you are subject to the criminal law, including the criminal jurisdiction law of the nation state, in the United States, the subnational state, the state of California, that arrests you, right? Okay. Now, the problem is this. Suppose that the criminal law of that nation state exceeds the jurisdictional boundaries provided by international law for what a state can properly do. You would think that you would be able to raise that issue in your defense. The problem is, as many of you already know, in many nation states you cannot. These are the states that are so-called dualist because they treat national law and international law as separate systems. And in many cases in states like the United States that are mixed, and sometimes we treat international law as binding our courts, sometimes we don't. So, for example, we have some relatively new anti-drug laws of the United States which apply extraterritorially even where there is no proof of importation or intent to import the drugs into the United States. However, these statutes state that international law cannot be raised as a defense. International law must be raised, if at all, by the state of the defendant's nationality. And it will not surprise you to know that many states of nationality are not all that keen to raise the rights of their drug smuggling citizens. So, must I, as a random person, obey from, let's say, Guatemala, thinking of taking a boat to the Bahamas, must I obey United States law? I can't tell. Now, the presumption against extraterritoriality cannot solve that problem. But I definitely agree with Professor Dodge that it can mitigate that problem. Let me say one more thing to be provocative. This system of misfit between national and international law is not just a problem for the United States, it's a problem for all countries except very strictly monist countries that allow all international law to be raised in their courts. And it's a problem for all persons dealing internationally because you don't know necessarily the legal status of the countries that you may or may not be dealing with. Let's be clear. If I make a statement denouncing the government of Singapore and calling for its replacement, I may or may not be violating the law of Singapore. Specifically, I will be violating the law of Singapore, but whether I will be protected against that excess of jurisdiction depends partly on whether I ever go to a country with an extradition treaty to Singapore and whether the United States, as my state of nationality, wants to back me up. Okay. So this makes hash of the principle of legality. The point of legality is to ensure that persons have the opportunity to know what law they must obey, where, because of technicalities of public international law, we cannot do this, legality is compromised. So here's why I think, from the criminal law point of view, the presumption against extraterritoriality is a good thing for a common law country like the United States, which does not have a full criminal code. Most of you civilian lawyers have criminal codes where criminal jurisdiction is fairly clearly stated in your codes. Sometimes, arguably, it's overbroad, but that's your business, right? Up to the point of illegality in international law. The way the British started, they had very, very strict territoriality. Every element of the crime had to be committed in England, often in the same county. There's a famous case. Man assaulted another man on a ship. The victim was taken off of the ship and died on land. The admiral could not prosecute the killer for murder because didn't die in the admiral's jurisdiction. The county could not prosecute because the man was not attacked on land. By the way, something like that is still the fundamental law of England. Statutes, or the law, the criminal law anyway, has no extraterritorial effect unless Parliament specifically says so. That indeed is one way that we could run this presumption against extraterritoriality, and I don't think that either of you would agree with that. I don't agree with it either. But I'm going to suggest a slightly different way of working it than Professor Dodge suggested. And here's where I'm going to be going. I tried to ask a question at the very beginning about what we meant by effects. You remember, we're talking about whether a territorial effect is enough to give jurisdiction. Now, there are two kinds of territorial effects. One is a random bad effect that you can imagine. You have an antitrust conspiracy among Russian natural gas producers, which that they only sell to Europe, but economics being what it is, eventually gas prices rise in the United States. The other type is where the effect is not just randomly bad, but is an element of, in the case of the things I'm talking about, element of crimes. The death in a murder case. The payment in, the payment in a kidnapping case is not an element. But the place where someone is being held, the place where the demand is made, any crime where you need a result, you will have, you might say, a place element. Now, the tradition of criminal law jurisdiction really began with where the acts were done in many countries around the world. And this idea of results elements being enough to give jurisdiction is a new one. But I think it makes perfect sense in a lot of these cases, and Morrison, though it's not a criminal case, is one of them, where it does make sense to say the place where the stock is traded is the place where the last result element, the getting of money from the fraud, takes place. And my suggestion for what is territorial for the purpose of extraterritoriality in criminal cases is this. A case is territorial to a state if any material element, action, or criminal result occurs on that territory. A case is extraterritorial if none of the elements occur in the state. And that would match up very closely with what I think is practice around the world. And also, it matches up fairly well with practice within the United States in our, you might say, conflict of criminal law cases. The idea of the shooting across the river, which state can prosecute? The answer very clearly is both states. Okay, now, that's obviously a very different view than Professor Dodge gave you. Or is it? I actually don't think it is that different in the results it will reach. Because the presumption against extraterritoriality is merely a step. Just because there is a territorial element does not mean we give up and we don't look at what the ambit, the substantive ambit of the statute is. And in this case, even after we've said, well, this is territorial, but because we have an element here, we don't have to worry about this presumption. We can then go and look for what the focus of Congress is. And let's be clear, we do this all the time. If you kill me right here, you've committed murder under California statute. But if you kill me up the road in Yosemite National Park, that's within the ambit of the federal murder statute as well. So we do this sort of idea all the time. The place where the presumption, under my view, would have its bite is where there are no elements in the United States, and then there would have to be a strong indication, as Morrison says, in order to overcome this presumption, a strong indication of congressional intent to have the matter applied. And I think your focus test would give us results that are very much like what we have. I wonder about some of the antitrust stuff. I think you would see a limitation to antitrust cases where there was a direct effect, that the conspiracy had a specific direct effect of trades by the conspirators made in the United States. But it wouldn't change things all that much. What it would do is it would give people who act with respect to the United States a better chance of knowing in advance whether they must obey United States law. And in the criminal law, being certain of whose law you must obey is, in my view, one of the foundations of what criminality ought to be. Thank you.
Thanks so much for 3 wonderful presentations. I know that you're going to have a lot of questions. Maybe I can... I have one very basic question about this presumption, which maybe it's too simple. But why, since now that Congress knows that there is this presumption, first of all, why doesn't Congress simply say where it wants extraterritorial application, where it doesn't? And secondly, doesn't it make sense, now that we know that there's this presumption, to expect Congress to do that?
My answer to that is yes. That's the point that Professor Dodge made about it, and it'll work.
So my answer to that is no. I do think it matters what the presumption says, because although in fact in Aramco, Congress quickly acted to amend Title VII, although in fact after Morrison, Congress quickly acted to amend the Securities Exchange Act, although perhaps ineffectively, as Frank was alluding to. It did that because it was already engaged in a legislative process in both of those cases, with Dodd-Frank on the one hand, with the 1991 revisions to the Civil Rights Act on the other hand. And we know how hard it is to get stuff through Congress. Just because a majority of members of Congress believe something ought to happen doesn't mean it happens. We have a filibuster, we have a committee system, we have so many transaction costs to reflecting the will of the elected representatives that I think if you're going to have a presumption, the presumption has to have a normative justification. You can't just say it's like driving on the right-hand side of the road or the left-hand side of the road. It doesn't matter which, so long as everyone does the same thing. In this case, it does matter what the content of these interpretive canons are.
Could I respond?
Of course, of course.
Yeah. I actually, I mean, I agree that you will not have Congress immediately responding to these things. But I do believe that if the Supreme Court, in a few more cases, makes it clear that a presumption has bite, then Congress, in its new legislation, will start acting more responsibly. And indeed, in the parts of this paper that I didn't read because there wasn't enough time, I have pointed out some places where I believe that Congress has been, on average, more responsible in doing this than the courts have been.
Okay, I wanted to ask Professor Curran, actually, and Professor Dodge talked about this too, the Kiobel case and the oral argument. And I was struck by what you had to say about Justice Kennedy, which is what we often say about, although people were wrong when they said it was going to be 5-4 with Justice Kennedy making the difference in the Affordable Health Care Act case. But in this case, it sounds as though it really is correct. And I went back and looked at the government's brief in the Kiobel case. And the government seems to be going where you maybe are suggesting Justice Kennedy is going, which is to say, well, Filartiga is good law, but especially in these circumstances where the alleged primary tortfeasor is a foreign sovereign and the defendant is a foreign corporation of a third country, the United States cannot be thought responsible in the eyes of the international community for affording a remedy for the company's actions while the nations directly concerned could. A decision not to create a private right of action under U.S. law in these circumstances would give effect to the court's admonition in Sosa to exercise particular caution, and so on. And I'm wondering, do you see it going that way? Or I know you don't want it to go that way.
I have to tell you one thing about the government. I mean, and I wish Bill Dodge had written the brief because
So do I.
I'll tell you, the second brief of the government was a total surprise and a shock. They just changed course on
The first brief's really good.
from the first oral argument to the second oral argument. The U.S. government changed course on the ATS, and so no one could figure out what the position was. And really got into a lot of trouble at that second oral argument. And Scalia really pressed him, and I have to say, I had a lot of sympathy for the questions he got that second time. I don't know how you felt, but I mean, you know, he said, well, what kind of credibility do you expect to have at this point? And I don't think he explained the position of the government, and I'm at a loss to understand it as well as to what it is that the government really wants. And I don't know if you can do a better job, Bilby, since you were more closely involved.